June 28th, you signed an order compelling us, the defendant, to respond to discovery sent by plaintiff, which we already did. However, just a second. However, on July 5th, we did submit the discovery. My legal secretary went to his opposing counsel's office and submitted it in person. If you take a look at what we filed, motion to set aside on March 18th, these are about 120 documents we sent to the opposing counsel. He also returned the check for $500 that he ordered us to send to them. We'll file a motion to set aside the default judgment. We also filed a summary judgment. When we had the hearing for the summary judgment, you said that you want to hear the defendant testify and deny the summary judgment. And we're set for trial tomorrow, Judge, in your court.
Response?
Well, Your Honor, the defendant's urging you to make an extraordinary order without bringing forward even the most ordinary of evidence to countermand it. And it's extraordinary for at least three reasons. First, Mr. Ndiene is asking you to set aside a sanctions order, which was a death penalty sanctions order, which you made on the merits rather than seeking relief by way of an appeal. Secondly, he's asking you to do that the day before a nominal trial setting, despite the fact that this order was made on November the 29th last year, and he also made an earlier order on October the 25th last year, striking the defendant's answer for discovery misconduct. But thirdly, even if this motion had been filed timely after the sanctions order had been made, or if the defendant had filed an appeal by way of mandamus, as this is a death penalty sanctions order, it's bound to fail. And it's bound to fail because they cannot satisfy any of the Craddock test. First on that, there's no good reason that they didn't attend the hearing. There was one hearing, as Your Honor will recall, on June the 28th on the motion to compel. There was a second hearing on the motion for sanctions on September the 13th. They didn't attend either, and they haven't explained why. Contrary to what Mr. Ndiene has just submitted to the court, the documents weren't produced on July 5th at all. Some bank statements were finally produced on October the 12th after you had made the sanctions order. Secondly, on the Craddock factors, there's definitely no meritorious defense. As was submitted on the motion for sanctions, the defendants admitted that she didn't pay my clients, the plaintiffs, the sale price for this property. And so she cannot possibly succeed at trial on a submission that she's the record owner of this property, and you've already entered a declaratory judgment saying that she is the plaintiff's tenant. And thirdly, there would be extreme prejudice to my clients if this order were to be granted today. Indeed, it is effectively rendering the sanctions process meaningless, because if we're ordered to go to trial tomorrow without any discovery, we are in no better position than we were in back in June when we started this process. The court would effectively be saying, well, Mr. and Mrs. Pacina, thank you very much, but we want to hear from you tomorrow, despite the fact that the plaintiff has not provided all the documents in her possession, provided her initial disclosures so that we can properly depose witnesses. And fundamentally on the sanctions point, and this is addressed in the short response that I filed with apologies for the lateness, but there's an affidavit there from Michelle Alden confirming that none of the sanctions have been paid. And there were effectively two tranches or two orders. The first was a payment of $500 for attorney's fees. And as I act pro bono in this matter, that was to be paid to the Dallas Volunteer Attorney Program. That was not done. Defendant did send us a check for $500, which I voided and sent straight back, because I am obviously not accepting any fee in this case. The second order, on the sanctions order, the defendant was ordered to pay a further $500 in attorney's fees to the Dallas Volunteer Attorney Program, and also $1,000 by way of monetary sanctions, also to DVAP. That has not been done. So once again, on the extraordinary nature of this request, you're being asked to effectively set aside an order on the merits when the underlying discovery abuse has not been remedied, and then you're being asked to send the plaintiffs to trial tomorrow. On that note, as Your Honour is, I think, aware by now, we have abandoned any remaining claims, and therefore, if you dismiss this motion, as I submit you simply must do for its total lack of merit, then the only issue remaining is for us to seek our final judgment, and there's a motion before Your Honour, which is to be heard today on that. And if Your Honour will just give me a moment to consult my notes and make sure I've covered everything.
Let me ask Mr. Onion.
Judge, I didn't hear what you said.
I want to ask you a question.
Sure.
Why didn't you attend the first two hearings, or why didn't your client attend the first two hearings?
Judge, I was not aware of it. The opposing counsel was not conferencing us. He was filing notice of hearing. Is even in the photos. You can see where your clerks right there, no conference. I was not aware of it, and this was during the December time. Many people in the office are out because of the COVID. But as far as the discovery he sent to us was interrogatories and production of documents. We have produced everything we have. I've already told him, even before I started filing this motion, that I didn't have anything else to send to him. Matter of fact, sometime in 2021, we came to your court. We were supposed to go to trial. On that day, he was bringing up that he didn't get all the discovery from him. I told him before you that I've given it all to him. And you said he cannot be talking about discovery when we were sent for trial the next week. And then on that next week, you told us to come in down there. And the last minute, your office called us and canceled it. And since then, he's been filing these motions in the court, sending orders to you without my knowledge, because he knows my number. He can pick up the phone and call me. My client and his client were people who were introduced by a seller who brings people together to buy property. He sued that person. He never got a service on him. My client is an innocent bystander. He purchased the property in good faith, and she signed the sales contract as well as special warranty. Special warranty. I don't know what my client did wrong in here. You cannot sell a property after 8 years. You show up and say, hey, I thought it was a lease. Okay. That's not what they signed. They have to live by the contract they signed. And my client be paying.
I get that. I can kind of understand what you're saying in terms of, well, give me 1 second.
Your Honour, may I make two brief reply points there?
No, 1 second. Sorry about that, guys. Go ahead and make your response, Mr. First.
Firstly, Your Honour, with regard to Mr. Onyena's suggestion that he wasn't given notice of the hearing, that is absolute nonsense. It is well documented, both in the certificates of conference and his submissions at the hearing, that Mr. Onyena was ignoring my telephone calls, and it got to the point where he even took himself off e-file service at one point, so that I was forced to send documents or to e-file and serve, and then send them by first-class mail and by email in an attempt to get a response. That is well documented, and that's not an explanation as to why they did not attend either hearing. Secondly, and this is the absolutely crucial point in the case, Your Honour, the warranty deed that Mr. Onyena refers to was forged, and we have the sworn affidavit, and that is before the court, of the notary who purportedly witnessed the deed, testifying on oath that he never met either of the plaintiffs, and that in his view, he had never witnessed that warranty deed. It's a sham, it's a fraud, just like the defendant's case. Those are the 2 points I wish to make.
Okay.
Yeah, Judge, if I may, he said the person that signed the affidavit said she never saw my client or the plaintiff. This was the document the plaintiff produced. Okay, the plaintiff was one that produced the document to this other person, Mr. Gonzalez, and Mr. Gonzalez was the person who was bringing them together, and he was doing it for other people. And she signed the document, and even in their pleading, they mentioned in there.
Sorry, but Mr. Onyena is testifying. There's no evidence to that effect whatsoever, and the notary says it's forged.
The same thing you testified. The notary is not here. We haven't have a testimony from the person. However, this lady waited 8 years after the sale to come forward and file a lawsuit and started claiming that this was a lease. If it was a lease, my client was paying the monthly mortgage, paying the property tax. There was nothing that the plaintiff was paying. And they both don't speak English either. So she couldn't say she couldn't understand that person because somebody translated everything to them. And she also even went to the bank and told the bank for my client to start making the payment. This is a contract for sale of property. And this property is almost paid off. And she showed up now to ask the court to give her the property back. If somebody defaulted her, it would be Mr. Gonzalez. Okay. Mr. Gonzalez was not my client's agent at all. However, in the summary judgment, you did say that you want to hear testimony from parties in this case as to what happened.
I couldn't understand what you just said. Say that again.
I said in the summary judgment, you did say that you want to hear testimony from the parties in this case, Your Honor.
That's not my recollection of the hearing, but Your Honor will no doubt set us straight on that.
Okay. I couldn't understand him, I don't think, anyway. Sorry, sometimes it's hard to understand. You're cutting kind of in and out, at least when I can hear. So, all right. I'm going to go ahead and how much? So he wrote a check for the 500, but it wrote to the wrong place. Is that kind of the deal, Mr. First?
He wrote one check for $500, but he's been ordered to pay $2,000, and
Okay.
he sent it to our office, not to DVAP. And frankly, given Mr. Onyena's history, I was never going to bank that check and transfer the money to DVAP, and that was what he was ordered to do anyway. He was ordered to pay DVAP, so I voided it and sent it back to him.
But the other said that the other said that we should pay 500. He didn't say we should pay to DVAC any person. That order was signed on.
It was sent in December as well, Your Honor, which was well after the order granting death penalty sanctions.
All right. I'm going to go ahead and grant the motion to set aside the default judgment. I'm going to order that conditioned on the payment of $3,000 by the Mr. Onyen's client, payable to DVAP. You have 2 weeks to go ahead and get that paid to DVAP. Mr. First, I want you to prepare an order. I'm going to go ahead and continue this trial setting. Is this a jury or non-jury case?
It's a jury trial, Your Honor. I've also got to insist, Your Honor, that we're provided with the initial disclosures and that they either produce all the documents in their possession, or they amend or supplement their interrogatory responses to state why they don't have the relevant documents.
Judge, if I may, if you see my filing on March 18th, everything is in there. Okay, and as for the initial disclosure, this case was filed in 2019. Initial disclosure didn't become effect until January of 2021. Besides, he didn't send me initial disclosure either.
I absolutely did, and they were e-files, Your Honor.
Did you? Okay, so Mr. Onyena, have you responded to the disclosures that were sent in January 2021? Have you responded on behalf of your client?
No. Judge, I said his filing was 2019. The initial disclosure came into effect January of 2021.
Okay, you still have to answer it. So, Mr. First, go ahead and include that in the order that those need to be answered within 30 days. Let's go ahead and reset this trial setting as well. How does July 12th sound?
Judge, may I get my calendar?
Sure.
Yes, Judge.
Does that work for you as well, Mr. First?
I'm just currently checking my, it appears to be free on my calendar. I'm just checking my deadlines. It appears to be open, Your Honor.
Okay. Ronnie, go ahead and reset it to July 12th.
Yes, sir.
Okay. Mr. First, you kind of understand what the order is?
Frankly, no, Your Honor.
Okay, so we're
we've now
setting aside the default judgment, condition on the payment of $3,000 by the plaintiffs within 2 weeks. The check needs to be, and it needs to all be in the order. The check needs to be payable to DVAP. And if they fail to make that payment within 2 weeks, then the default judgment will be made final.
Does that also mean that the defendant's answer is reinstated, Your Honor?
The defendant's, again, a conditional reinstatement of the answer pending the payment of the $3,000.
Very well, Your Honor. I will submit a Word version of the order, and if Your Honor needs to make any changes,
Judge,
then
if I may, can he include the address of where to pay the money to in the order? Please?
Include that, and you don't need to just send us I can interline. Don't give me a Word version. Share it with Mr. Onye and go ahead and e-file it and email it to Rhonda. At the beginning of the order, make sure it says that this was heard on May 23rd, 2022, as opposed to just on this date. And again, if you can, it'd be nice if Mr. Onye would go ahead and agree as to form as to this, but if you can't get an agreement as to form, just submit it within 24 hours and we'll try to get it signed as soon as we can. All right, guys.
very well, Your Honor.
Thank you. You have a good day.
Thank you, Judge.
And you, Your Honor.
All right. Anyone else here on the dismissal docket?
Your Honor, I'm sorry. Hi, this is Marcia Ewu.
Okay. What case are you here on?
It is Diamond Collins versus, let's see, Lucero Vega Lozano, DC 1916993.
I see it. DC 1916993.
Yes.
Okay. What's going on with that one?
So we were scheduled for trial, I believe, in April. However, when I called to see what number we were in line, I was told that the defendants or someone from the defendant's law office contacted the court and said that we had gotten this case settled. But we haven't gone to mediation or anything like that. So she told me to contact them, which I did. I never heard anything back from them. And then the court coordinator emailed me this DWAP notice to, call and talk to the court about it. So we were scheduled for trial, but it was taken off the docket because of the defendant's attorney statements. So I really just need another trial date.
When do you want to be set?
A July date would be best.
Okay. You want to do July 12th?
Yes, that's fine.
Rhonda, go ahead and set this Collins v. Lozano case for trial on July 12th.
Got it, Judge.
All righty. You are excused, Ms. Uwu.
Thank you so much, Your Honor. Have a great day.
You too. Have a good day.
Bye-bye.
All right. Let's go to the Guevara versus Riojas meddling case. Everyone here in that case?
Yes, Your
Yes,
Honor.
Your Honor, we're all here.
Yes, Your Honor.
Give me 1 second.
Rhonda, this is Jody Jenkins. I don't know if the judge is finished up with the dismissal docket, but we had one more on the dismissal.
Go ahead and just wait. He's gonna call it again. Once he gets through with this hearing, he'll make another announcement.
Yes, ma'am.
Just
Thank
to know
you.
you're here. Mhm.
Okay, Tony, are you ready? Tony, are you ready?
I'm sorry, yes, Judge.
Let's go on the record on DC 222477. Guevara versus Riojas Medellin. Council, make your appearances.
Rachel Montez, counsel for plaintiffs.
Cecilia Hindman, counsel for defendants.
Maria Estevez here as the guardian ad litem.
All right, let's go ahead and proceed.
Your Honor, we would call you Dear Guevara to the stand, please,
Okay.
or to the Zoom.
To the Zoom. Okay, the Zoom's dead. Okay, is that Yadira? She keeps on coming in and out of the room. I'm not sure if she has some kind of connection issues. Is that Yadira?
She was calling me right now, Judge. I think she's trying to get back into the Zoom.
Yeah, she's come in and out at least 6 times. So,
Sorry, she's on her work break, Your Honor.
okay.
Your Honor, this is Diane Teichman, the interpreter.
Okay, I'll swear you in once, Miss Yadira. Yadira, you need to, and I don't know, it says Yadira, I'm sure that's her. Ma'am, you need to turn on your camera so that we can see you.
Señora Yadira, si usted nos puede oír, por favor, pon su cámara para que nosotros podamos verla.
Sí, está bien, ya la puse.
Yes, I just put it on.
Okay. All righty, let me find you. Ma'am, please raise your right hand. Do you swear, sorry, first the interpreter, please raise your right hand. Do you swear or affirm that you faithfully translate the matters in this case from English to Spanish to English to the best of your ability, so help you God?
I do, Your Honor. Señora Yadira, por favor, alce su mano derecha para tomar el juramento.
Okay.
All right, ma'am. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
¿Usted jura que el testimonio que va a dar aquí va a ser la verdad, solamente la verdad y nada más que la verdad?
Sí.
I do. Puede bajar su mano.
And Ms. Teichman, if you could go ahead and state your full name and your certificate number.
Diane Teichman, Master License Court Interpreter, JVCC, license number 393.
All right, you may proceed.
Thank you, Your Honor. You are Yadira Guevara, is that correct?
Es
Yes.
correcto. Ustedes, Yadira Guevara, por favor, espere hasta que yo termine de interpretar. Ustedes, Yadira Guevara, ¿correcto?
Sí, así es.
Yes, that's right.
Enrique Ruiz Guevara is your son, is that correct?
Enrique Ruiz Guevara es su hijo, ¿correcto?
Sí.
Yes.
And you have lived, or he has lived with you since the time of his birth, is that right?
Y él ha vivido con ustedes desde que él nació, ¿correcto?
Sí.
Yes.
And his date of birth is August the 13th, 2010?
Y la fecha de su nacimiento es el 13 de agosto de 2010.
Sí, así es.
Yes, that's right.
And he was 9 years old on May the 10th of 2020 when this accident occurred?
Y él tenía 9 años de edad el 10 de mayo en el año 2020 cuando ocurrió este accidente, ¿verdad?
Sí, así es.
Yes, that's right.
Okay, and on May the 10th of 2020, your son Enrique was following his grandmother and ran across the street and got hit by a car. Is that correct?
El 10 de mayo del año 2020, su hijo Enrique estaba tras su abuelita de él y él corrió cruzando la calle y fue pegado por un carro, ¿verdad?
Así es.
That's right.
And the Dallas police came out and investigated the incident occurred at the 200 block of West Ohio in Dallas. Is that right?
Y llegó la policía de la ciudad de Dallas y este accidente ocurrió en la cuadra número 200 de la calle West Ohio en la ciudad de Dallas, ¿correcto?
Así es.
That's right.
And the Dallas police officer who investigated this actually said that it was your son, Enrique, who caused this incident. You recall that?
Y usted recuerda que el oficial de policía de la ciudad de Dallas dijo que era su hijo, Enrique, que había causado este accidente. ¿Usted recuerda esto?
Sí.
Yes.
Okay, and you hired my law firm, Montez Law Group, to bring a claim against the driver of the car that hit your son, Enrique. Is that right?
Y usted empleó a mi bufete de abogados, Montes Law Group, para traer una reclamación contra el que estaba manejando el carro que le pegó a Enrique, ¿verdad?
Sí, porque mi hijo iba pasando y el carro no se detuvo.
Yes, because my son was crossing and the car didn't stop.
And so we brought a claim and we were able to settle it for the full amount of the policy limits afforded to that driver. Is that right?
Y trajimos una reclamación y resulta en éxito que podíamos sacar el número, I'm sorry, I'm cutting out. El número total de la reclamación de los límites de póliza del que estaba manejando el carro, ¿verdad?
Ajá.
Ajá.
And the full amount of the policy limits was $30,000. Is that right?
Y la cantidad entera de los límites de la póliza era $30,000, ¿correcto?
Okay.
Okay.
Is that your understanding of what we settled your son's case for? $30,000 in total?
Usted entiende que así llegamos al acuerdo del límite del póliza de $30,000 en su caso de su hijo, ¿verdad?
Sí.
Yes.
And out of that, you're paying attorney's fees, attorney's expenses, and what's left of the medical bills. You understand that?
Y de esa cantidad usted va a pagar los honorarios de los abogados, los gastos de los abogados y los gastos médicos, ¿correcto?
Sí.
And as far as medical bills are concerned, we're paying a total of $9,623.80 in medical bills. Is that right? Is that your understanding?
Los gastos médicos eran un total de $9,623.80. ¿Usted recuerda eso?
Sí.
Yes.
Okay, and your son, predominantly his injuries were he had a head injury. Is that right?
Las lastimaduras que sufrió principalmente su hijo era de su cabeza, ¿correcto?
Sí.
Yes.
And thankfully, the MRI they did of his brain showed that it was normal with the exception of a pre-existing arachnoid cyst. Is that right?
Y la MRI, radiografía que tomaron, salió resultado de que era normal, menos una cista preexistente, ¿correcto?
Sí.
Yes.
And although that some of his bills were paid by Medicaid, we have determined that there's no Medicaid lien on this case. You understand that?
Y también entiende usted de que aunque unos de sus gastos médicos fue pagado por la Medicaid, hemos determinado que resulta que no hay falta de pago a la Medicaid. ¿Correcto?
Okay.
Okay.
And, you know, as a result of this settlement, your son Enrique will be able to put the sum of $10,67.10 into an investment annuity. Is that your understanding?
Could you please repeat the amount?
$10,067.10.
Y como resultado de ese acuerdo, usted entiende que su hijo va a poder recibir en forma de una anualidad, una cuenta de anualidad. una suma total de $10,000, $66.10, ¿correcto?
Sí.
Yes.
And you've chosen an annuity that will pay him a one lump sum of $10,803.08 on August 13th of 2028. Is that right?
Y usted ha decidido tomar una cuenta de anualidad que le va a pagar una cantidad en total una vez de $10,000 o $10,803.08 en agosto del año 2088, ¿correcto?
Sí, cuando tenga 18.
Yes, when he turns 18.
And you understand that that money is his money and nobody else's, not yours or any other member of your family or anybody else. You understand that?
Y usted entiende que ese dinero le pertenece a él, que no es dinero que se puede dar a ninguna otra persona, que nadie más es propietario de ese dinero. ¿Entiende usted esto? Yes.
Sí.
And you understand that in this case, you have a right to take your son's case to a jury trial, in which case he might get more, he might get less, he might get zero from a jury.
Usted entiende que en este caso usted tiene el derecho de llevar este caso de su hijo a un jurado. En ese caso puede ser que usted saque más dinero, menos dinero o nada de dinero para nada. ¿Usted entiende que esto?
No sabía, pero como que era así, está bien.
I didn't know that, but either way, this is fine.
Are you asking the court to approve the settlement in the amount of the policy limits of $30,000 for your son Enrique in this case?
Usted está pidiéndole al juez que apruebe este resultado, este acuerdo, con los límites de póliza de $30,000 para su hijo?
Pues sí.
Well, yes.
Do you believe that this settlement of $30,000 is in Enrique's best interest, given the facts of this case?
Dado los hechos de este caso, señora, ¿usted cree que este resultado y acuerdo de los límites de póliza de $30,000 está en los mejores intereses de su hijo Enrique?
Yo pienso que sí, ¿no?
I think so.
And you understand that you can't ever come back in the future, nor can he, to ask for any other money or any other benefit as a result of this incident.
Usted entiende que en el futuro usted no puede regresar, ni él puede regresar a pedir más dinero, ningún otro beneficio en el resultado de este caso, ¿verdad?
Sí, está bien.
Yes, I do.
And do you believe that this settlement of the policy limits for your son is fair, reasonable, and in his best interest?
Entonces, ¿usted cree que este resultado del caso de su hijo en los límites de la póliza está en los mejores intereses de su hijo y es justo y está en los mejores intereses de su hijo, ¿verdad?
Sí.
Yes.
And are you satisfied that Enrique has made a good recovery after his injury?
Y después de haberse lastimado, ya se ha recuperado su hijo, ¿usted está satisfecha con la recuperación de su hijo?
Se ve bien.
Yes, he looks fine.
And he's doing well in school and he's doing well in his other endeavors. Is that right?
Y anda bien en la escuela y sus otros intereses y quehaceres, ¿verdad?
Sí, yo lo veo bien. Hasta ahorita lo he visto bien.
Yes, right now he looks good. What I've seen up to now is he looks good.
I'll pass a witness.
Son todas las preguntas que tengo.
All right. Anyone else have any questions?
Your Honor, I just had one question. Ms. Guevara, is your full legal name Yadira Guevara Gallegos?
Señora Guevara, su nombre entero
es
Yadira Guevara
Villegas. Villegas.
Villegas.
Ajá.
Ajá.
Thank you. I just wanted to confirm. I'll pass the
Gracias.
witness.
Solamente quería confirmar eso. No tengo más preguntas.
Okay.
Okay.
Mrs. Savas, do you have any questions?
Briefly, Your Honor. Ms. Guevara, my name is Maria Seves, and I'm the guardian ad litem in this matter.
Señora Guevara, mi nombre es María Aceves y soy la abogada ad litem en este asunto.
Okay.
Okay.
You understand that I was appointed by the court to represent the best interests of your son, Enrique, in this case?
Usted entiende que fui nombrada por el tribunal para representar los mejores intereses de su hijo Enrique en este caso, ¿verdad?
Ajá.
Ajá.
We had a chance to meet before today to discuss the injuries, the accident, and the settlement, among other things, correct?
Y tuvimos una oportunidad de reunirse nosotros dos para hablar del accidente, las lastimaduras y las recuperaciones médicos de su hijo y el accidente, ¿correcto?
Así es.
That's right.
We also reviewed the annuity proposals, and you selected one of the plans from the proposals that were presented to you, correct?
También revisamos las propuestas de cuentas anuales de pago en este caso y usted seleccionó uno de los planes presentados, ¿correcto?
Sí.
Yes.
Now, we also discussed whether there may have been insurance available under your own insurance policy for ERG, is that right?
También hablamos de la posibilidad de que si había disponible seguro bajo su propio plan de seguro ERG, ¿verdad?
Sí.
Yes.
And you indicated that you did not have any documentation related to that policy, is that right?
Y usted nos dijo que usted no tiene nada de documentación o papeles de ese plan de seguro, ¿correcto?
No, no tengo seguro.
No, I don't have insurance.
Okay, and at the time of the accident, you indicated that you may have had insurance, is that right?
Pero usted nos dijo que en el momento del accidente puede ser que había tenido seguro, ¿correcto?
Estamos hablando de seguro de carro, ¿verdad?
We're talking about car insurance, right?
Correct.
Correcto.
Sí, sí tenía, pero me cambié de compañía y perdí los papeles. Cuando ya termino la compañía, yo tiro los papeles, o por eso no sé cómo se llama.
Yes, I did have it then, but I changed plans. I changed companies. And when I changed companies and the company closed, I threw away the papers.
Okay. Are you asking the court to approve the settlement because you believe it's in the best interest of your child, Enrique?
Usted está pidiendo al juez y el tribunal que apruebe este arreglo porque están los mejores intereses de su hijo, Enrique.
Yes.
No further questions. I pass the witness.
Son todas las preguntas que tengo. Paso el testigo.
Okay.
Okay. Any additional questions of this witness?
No, Your Honor.
Ma'am, do you have any questions for me?
Señora, ¿usted tiene alguna pregunta por el juez?
No, todo está bien.
Everything's fine.
Okay. Call your next witness.
I have no further witnesses, Your Honor. I do have an affidavit from the annuitist that I filed with the court, Your Honor, verifying that it does comply with the provision of the Texas Property Code in connection with annuities, and it's rated A and A minus in compliance with the Texas Property Code on these annuities. Obviously, the interest rate's not what we want it to be these days, but it does give him a lot more money than had it been sitting in the registry of the court. And that's the reason why we chose that option. We did also try to track down any additional insurance coverage in this particular matter, and we just could not obtain that.
How old is he when he gets the money?
18.
18, okay. All right, is there a recommendation of the guardian ad litem?
Yes, Your Honor.
Go ahead.
At this time, as the guardian ad litem, I am of the opinion that the settlement offer of $30,000, which is the defendant's policy limits, is in the best interest of the minor child and is adequate to compensate him for his injuries. So for that purpose, I would ask the court to approve the settlement. It is, however, my opinion as the guardian ad litem that I am concerned that there may be additional insurance available for the minor, and that those claims have not been made, and not pursuant to the plaintiff's attorney not making an effort, but because that documentation has not been presented to them.
Well, what is your recommendation then at this point?
Well, my recommendation is that the settlement as to the $30,000 be approved. But I would highly suggest that Ms. Guevara find those documents so that we can confirm that there is no additional source of potential settlement proceeds available for the minor.
Ms. Teichman, if you could translate that last part about the recommendation from Mrs. Sabas.
Señor Guevara, la abogada ad litem está recomendando que usted busque de nuevo, haga todos los esfuerzos que puede hacer para encontrar documentos o papel que comprueban que usted de su seguro de auto que tenía en el día del accidente para comprobar que sí hay otra fuente de seguro.
Voy a tratar a ver si hay papeles, pero como le digo, tengo la manía de cerrar todo, tirarlo. Pero voy a tratar de buscar, pero no le aseguro nada.
I will try my best, but I have the habit of once one account is closed, I throw everything away, but I will try again and try to find it for you.
And Your Honor, if I might add, just for the record, we did put all of the big ones on notice and came back with no policy. And the big ones, I mean, State Farm, Allstate, Farmers, Geico, you know, those kind of.
And she just doesn't remember who she was insured by at all?
I'm not sure. Your Honor, I don't know, Your Honor. I don't know if it's an unwillingness or no memory.
Okay, well, this will not affect that. Obviously, it's up to her to get that to you. And if it turns out you need another prove up, if there's more settlement, then let me know. Ms. Heineman, have you worked out with Mrs. Sabas the amount of the guardian ad litem fees?
Yes, Your Honor.
And is that $1,880?
Yes.
Is that right, Mrs. Sabas?
Yes, Your Honor, that's correct.
The court will approve the guardian ad litem fees, and Mrs. Sabas, I understand you recommend approval of the settlement and recommend and further recommendation to the mother to go ahead and try to find the rest of the insurance. The court will go ahead and approve the settlement as requested. Mrs. Sabas, as always, thank you for your help on this and service to the court. And there won't be many more of these, I know. So I'm glad you're able to do these while you can. And you guys have a great rest of your day, okay?
Thank you, Your Honor. May we be excused?
You may.
Thank you.
I understand there may be somebody else here on the dismissal docket. Is that correct?
Yes, Your Honor. Jody Jenkins here for Truist Bank.
All right. What case number is that?
Case number DC 21-17874.
All right. What's going on with that case?
Your Honor, we served the defendant on April the 6th, and their answer was due May 2nd. We're just waiting on our client to get an affidavit over to us so we can file a default. There's not been any answer yet.
All right. Rhonda will give him additional 30 days. Okay.
Will do. Thank you, Judge.
Thank you. Thank you, Mr. Jenkins. You have a good day.
Thank you, Your Honor. You do the same.
All right. Our next case is the Central Living Trust versus City of University Park Board of Adjustment. Are both sides here on that?
Yes, Your Honor. Trey Cox here on behalf of plaintiffs.
And yes, Your Honor, Courtney Morris here on behalf of the City of University Park.
Okay. Tony, let's go on the record on DC 21-17275, Central Living Trust versus City of University Park Board of Adjustment. Counsel, make your appearances.
Yes, Your Honor. Good morning. Trey Cox and Cody Johnson here on behalf of plaintiff.
And Courtney Morris here on behalf of the City of University Park.
All right. I've read everything. You may proceed.
Yes, thank you, Your Honor. I have a PowerPoint that I would like to share with the court if I may, but my computer is telling me that I am disabled for screen sharing. May I
Go
request
ahead.
screen?
Go ahead.
Thank you. All right, great. Can you see that, Your Honor?
I can.
All right, wonderful. Thank you so much. I'm here on behalf of the trust, and we are asking Your Honor to grant summary judgment and reverse the decision of the board and the city with respect to declaring the property at issue a double frontage property. There are three reasons that this should be the result today. Number one, Texas property rights in general favor the property owner absent explicit restriction. Number two, the board failed to apply the law correctly and ignored the plain text of the ordinance that is issued today. And finally, the board's decision has caused great hardship to the trust in this particular case, which I will go over and explain in detail. Now, again, I mentioned the state of the law here in Texas, and this is a general summary of it in one representative case, and that is that absent a restrictive covenant and subject to zoning requirements, a landowner has the right to build what he pleases on his property. When we get into a situation like this, where a city or a property board makes a ruling, we're then allowed to appeal it to Your Honor. And the standard that Your Honor will use in this process is an abuse of discretion standard. But here, the case law, and this is a Dallas Court of Appeals, they make clear that if there is a failure to reference guiding rules or principles, or when the decision clearly fails to analyze or apply the law correctly, that is an abuse of discretion. And I want to point out to Your Honor that Your Honor takes this issue up de novo. You do not have to give any deference to the findings or determinations of the city with respect to the law. Now, how do we find ourselves here? This is the lot that is at question in this case. And it's a lot in University Park, and it's bordered by two streets. And I say it's bordered by two streets, and I use, as Your Honor can see here, the DCAD property map. This is the official map. It's got two streets, Grassmere, which starts at the bottom and then bends towards the top and intersects Hunter's Glen. So we have two labeled streets at issue here. And then what happened was we had a new purchaser, and what they wanted to do is they wanted to build a fence around the property. And so they went to the city and said, may we build a fence around this property? And what the city concluded was that this is a double frontage lot. That's the conclusion. And when you have a double frontage lot, you have to also have double setbacks. So it reduces the amount of buildable space significantly. Now, let's look at what the standard is. The parties have agreed, and it can be found in paragraph 9, and I'll show it to Your Honor as well. But in paragraph 9 of the city's response, they admit and concede that all parties have identified this lot as a corner lot. Once it is identified as a corner lot, this is the statute that they must interpret. A double frontage corner lot must have frontage on more than two streets. That is the standard. That is the rule that must be applied.
Doesn't the city take the position that there are other situations with these, I guess, I don't know what you call them, these curves, where they've called them double frontage lots or determined that they were double frontage lots, and that if they did it differently here, that would be somehow violating the precedent of the Board of Adjustment?
Yes, Your
Yeah.
Honor, I believe that is the position or one of the positions that they take here. Although, let me advance you. I'm gonna go straight to it and answer that question for you because I've got the quotation right here from Patrick Ball, the Community Development Director. And essentially what he says is, I'm not bound. He says, I'm just throwing that stuff out, but the city is not bound by that. So this is a question from the panel. Is it the city's position that prior decisions of the Board of Adjustment is precedent that this Board of Adjustment can't make a decision that may be considered to be in conflict or to the contrary? No, I wouldn't put it that way. So when actually posed that question contemporaneously, the city said no. Now today they take a little bit different position on that and they try to take that back. But again, I guess here's what I want to point out. We have to interpret the statute. That is the most important thing that we do. And I would emphasize the city of Glen Rose, Texas versus the Reinke opinion, where they say, while the city administrator or Board of Adjustment may have the authority to determine particular cases, neither has the authority to promulgate new and ex post facto legislation or to write words into or out of and change the zoning ordinance. Again, that's why the standard that we have to deal with here is the abuse of discretion, that you have to follow the law. And the prior, I mean, there's no evidence of what they did previously. The board has already said, or the chair of the board has said, I'm not bound by that. And here's the statute that they have to deal with, which is it has to be fronted by more than 2 streets. And the director is very honest. What he said is, hey, I just made a determination, and this is the exact word that they use in their brief, a determination that the fork, Grassmere Lane, form 2 separate.
I apologize. I need to take a quick break.
Okay, thank you, Your Honor.